Everybody at this webinar organized by the Amsterdam Centre for European Studies and the Amsterdam Centre for Transformative Private Law. My name is Eva Vermeulen and I'm a PhD candidate at ACT and a co-organizer of this event. And I will tell you a little bit more about the program and the idea behind this webinar. So as many of you will know, yesterday was a great day. Because my colleague and the other organizer of this event, Laura Burgers, successfully defended her PhD thesis on the democratic legitimacy of judicial lawmaking in European climate change litigation. She did that extremely well, so once again, congratulations to Laura. And today's webinar is just to celebrate this wonderful achievement, but it's also a kind of a follow-up to discuss the topic from a slightly different angle and focus on one interesting sub-theme of climate change litigation, and namely the choice to either sue the state or a company for unlawfulness with regards to climate change. So actually it's all in the name. Who is legally responsible, the state or the company? For the program, we will proceed as follows. First, Laura will give a short presentation on the findings of her research. Then the floor will be given to Maarten de Zeeuw, and he will tell us all about next week's lawsuit that Greenpeace has filed against the state for giving unconditional state aid to KLM. After that, we will listen to the reflections on this topic of two experts on climate change litigation, Professor Monica Hinsberger of Graz University and Professor Veerle Heijvaart of the London School of Economics and Political Science. And this discussion will be moderated by our very own Professor Chantal Mak, Professor of Private Law at the UvA. And after this discussion, we have room for a Q&A, and we hope also a broader discussion with the audience and experts. And it's good for you to know that you can ask your questions all the time via the Q&A function. So you can just type it. You can let us know. We can all see your questions. You can let us know whether you want to post them yourselves in real life, or if you, or whether you want to just type the question and that we will pose it to the expert of your choice. And please let us know who is the expert of your choice. So I think, I have said it all. I am looking forward to the exchange, and I will now give the floor to Laura.
Thank you very much, Eva, and thank you all for putting congratulations in the chat. It's very kind of you. Lisa, can you please put up my PowerPoint? Okay, thank you very much. Then I'll start. Yes. So thank you very much. This is actually the first time that I ever put, Lisa, can you go to the former slide still? Sorry, thank you. This is the first time ever that I put doctor in front of my name, and I must admit that it was fun to put it there. I feel very happy and honored to speak at this event today, especially together with a set of speakers whom I greatly admire. And also I think that we have now people attending from different countries at the same time is one of those things that makes these difficult Corona times a bit bearable. Next slide, please. My PhD thesis is entitled Justitia, the People's Power and Mother Earth. And the topic is the democratic legitimacy of judicial lawmaking on climate change in European private law. And if you want a copy of this book, either a digital one or one on paper, please send me an email indicating your address and we can send it to you. In my thesis, I show inter alia how climate change litigation pushes for the emancipation of three groups who now fall out of the polis of our constitutional democracies. Three groups who are typically affected by climate change, namely people abroad, future generations, and non-human beings. Today, however, can we still go to the, Today, however, I focus on the difference of legitimacy between cases against states and businesses. Next slide, please. Democratic legitimacy ensured by the governmental separation of powers is a big thing in climate change litigation. We can see this in reactions of corporations that were sued over climate change. The German energy company RWE mentions in its defense against the claim of the Peruvian farmer Mr. Luya, climate change is a global political challenge that cannot be addressed by holding individuals liable under civil law. And Shell gave a similar response to the climate case Milieudefensie initiated. We believe that climate change is a complex societal challenge that should not be addressed by courts. And also many academics find that climate change is a political issue that therefore should not be dealt with by the judiciary. In 2015, the Hague District Court rendered its decision in the now world-famous Urgenda case. And it ordered the Dutch government, based on tort law, to make its climate policy more ambitious. Mostly in the Netherlands, numerous academics said the court overstepped its role in the governmental separation of powers. Next slide. Such standpoints are not strange when looking closer at the essence of democratically legitimate lawmaking. And in my PhD thesis, I defined democratic legitimacy with the aid of work by a German thinker called Jürgen Habermas. I will not dwell upon it too much now, but it is important that essential for democratic legitimacy is that we make law together as citizens. This means that we do not want to be bound by law made by a single person, including not by law made by a single judge. And this I called the legal boundary to the role of the judiciary. Judges may only apply those laws that were enacted by the citizens. In private law, this legal boundary actualizes in the rule of civil procedure that I labeled as the factual boundary. And this term then refers to the rule that in private law, judges must rely on factual submissions made by the parties. The parties may delimit the dispute factually. Now, for judges, there might be one reason to oppose democratic majority decisions, and that is where these endanger fundamental rights. And this also has to do with Habermasian theory. Fundamental rights form a precondition for democracy and vice versa in his theory, meaning that a violation of a fundamental right poses a danger to the democratic project as such, so that judges should then interfere. I combine this theory with something that we can witness, and that is a movement towards environmental constitutionalism, meaning that the environment is increasingly seen as pertaining to the area of fundamental rights. Against the background of my theoretical framework, this means that sometimes the judge has to interfere against democratic majorities. After all, a fundamental right is at stake. Next slide. This theory on democratically legitimate lawmaking, judicial lawmaking, is reflected especially in the cases against governments. When in 2015, the Hague District Court rendered its Urgenda judgment against the Dutch government, it relied on a private legal duty of care. Although the substance of this duty was influenced by human rights were not the legal basis of the judgment. Hence, it is unsurprising that the judgment faced so many critical reactions. It seemed to go against a democratic majority decision. Yet, in 2018, the Court of Appeal in this case, and also later in 2019, the Supreme Court, based the order on fundamental rights. Since fundamental rights or human rights are the only legitimation for a judge to go against democratic majorities, I think that in terms of democratic legitimacy, this was the right step. And although some academics remain critical, the general opinion among scholars is that this indeed increased the democratic legitimacy of the Urgenda case. Next slide. Now, for climate cases against businesses, similar issues are at play, but more indirectly. So let's look at two climate cases against businesses that came up so far in European private law, the RWE case and the case against Shell. Both defendants find that courts are the wrong avenue to determine climate obligations for enterprises. And this objection primarily echoes the judiciary's legal boundary. That is, corporations, at least normally, operate with governmental authorizations, and so far no explicit statutes seem to exist that would articulate their responsibilities related to climate change. The corporations thus rely on a lack of legality and assert this legality should originate in democratic majority decisions of the political branch of government rather than in the decision of a single judge. So why should they have to pave the way? Why should they have to pay for the consequences of their business that democracy so far approved of, and that moreover hugely profited society economically? Now let's zoom into the two cases to see how this objection works out there. Next slide. In the case against RWE, the Essen District Court denied the claim because it would be impossible to establish causality between the damages of Mr. Luya in Peru and RWE's German energy business. Yet, the higher regional court of Hamm did decide the case should go into the evidentiary phase, where RWE had objected that climate change should be dealt with by international politics rather than by a civil court. The court declared the claim admissible and showed itself willing to reconsider the causality in light of to be provided evidence. Vital in this regard is how the higher regional court reiterates the private law principle that harm should be compensated, even if the harmful conduct is not forbidden. Vital because it underlines that whereas in public law, what is not illegal automatically falls within the sphere of what is to be deemed legal, in private law, additional private legal duties exist, not to cause others harm, as we also saw in the Urgenda case on first instance. This means that this legal boundary argument did not seem to help RWE. That being said, the factual boundary might turn out to be more salient. It remains to be seen whether Mr. Luya can establish a factual causal link between, on the one hand, the damages he expects to incur due to climate change, and on the other, the business operations of RWE. Next slide. The claim of Milieudefensie against Shell will be heard very soon in December. It is remarkable that the claim does not ask for damages, but for an injunction. This move is strategic in light of the democratic legitimacy related legality complaint. After all, a lack of legality is less pressing when the norms concerns the future. Milieudefensie does not want to let Shell pay for energy sins that we all committed. As the district court mentioned in the RWE case, every person is to some extent an emitter. Instead, Milieudefensie confronts it with knowledge that any newspaper reader already has. The climate crisis has to be solved in the coming decade, and the only successful ingredients for this solution are corporate leadership, innovation, and political support for that innovation and corporate leadership. Next slide. In conclusion, my take would be that for democratic legitimacy of judicial decisions on climate change against governmental authorities, direct application of human rights is a necessary condition. This is, however, not true for claims against corporations, because private law duties there might provide democratic legitimacy in and of themselves. It remains to be seen how civil procedure, maybe in combination with more attribution science, might also allow to establish factual tort liability for business entities. And a priori, legitimacy concerns are less pressing when, instead of damages for past business operations, future-oriented injunctions are asked. After having researched climate cases for more than 4 years now, I could of course talk longer, but I would like to keep it at this and instead listen to our other great speakers. Thank you very much for your attention.
Thanks a lot, Laura, for presenting your research and thereby also drawing the bigger picture in which our discussion of today will take place. Let us now turn to Maarten, who will tell us a bit more about Greenpeace's climate case against the Dutch state.
Yes, thank you very much. And Laura, once more, congratulations with obtaining your PhD. Yeah, so just 1 month ago, we filed a lawsuit against the Dutch state as Greenpeace Netherlands, and next week the proceedings are already taking place. What we are asking for is that the 3.4 billion bailout for airline KLM will be revoked unless the state comes with better climate conditions to curb CO2 emissions. And how the state and KLM will make sure that those emissions are reduced is up to the state and KLM. Yeah, because right now the government allows KLM to continue to pollute at the same level of 2005, which just means a very minor reduction of CO2 levels. And we think this is a violation of the duty of care of the government based on the European Convention on Human Rights. For us, climate justice means that people have a right on a stable climate and protection from the danger of climate change, and that the state has an obligation to take measures against climate change. And in the Urgenda case, we have shown that the state has an enforceable duty to reduce emissions. Yeah, so why shouldn't those duties also apply for bailouts? So then the question, why are we targeting the government instead of KLM? And in order to answer that question, I have to go a few steps back. What we're seeing that's happening right now is that due to the COVID crisis, there's a strong consequences for our economy. And in response to that, governments are pouring billions of euros into the economy. And this comes in lots of different ways. So on the one hand, we have, for instance, the ECB that is buying corporate bonds, often from polluting companies like Shell. And then there's more visible state aid, like the $3.4 billion bailout for KLM. And from previous crises, such as the financial crisis, we know that after the crisis, the CO2 emissions went up again and started to surge again. And we think it's very necessary in light of the climate crisis that we shouldn't let that happen this time. And that's also the reason why we're targeting the government with this lawsuit, because we want that the response to the COVID crisis is in line with the Paris Agreement. But governments do not support companies that do not have a climate plan in line with the Paris Agreement. And the KLM bailout is a very tangible example of that. So that's why we focused on this bailout in this lawsuit. And besides legal considerations, the advocacy part is just as important for this choice. But besides that, we also strongly believe that corporations like KLM have a strong responsibility. They're making lots of money to pollute the atmosphere. They know the impacts of the fossil fuels that they use, so they're also responsible for the solution. And that's why internationally we as Greenpeace have a climate justice and liability project, and there we target both fossil fuel corporations just as well as governments that should come with better and more ambitious climate and energy laws to reduce our dependency on fossil fuels. And I would briefly like to give two other examples. So we're involved in the People versus Arctic Oil case in Norway, and actually currently the appeal is happening now at the Supreme Court. So this case was by Greenpeace Nordic and Nature and Youth, and they filed a lawsuit against the Norwegian state for granting new oil drilling licenses for the first time in 20 years in a newly opened area in the Arctic. So that's just an example of where we are targeting with a lawsuit the government. Then one example for corporations is the case in the Philippines, where in November 2013, 2013, Typhoon Haiyan caused the death of thousands of people, and people asked questions: did climate change make these typhoons stronger? And if so, should corporations also be contributed and profited to this climate pollution? Should they also be responsible for that? So that's why, together with community leaders in the Philippines, we also started a lawsuit there. So that's just two examples that, yeah, for us, it's if you're asked the question who's responsible for climate change, then for us it's not either or, it's both the state and both companies. And just, yeah, for example, now the KLM lawsuit, there's also other reasons besides the legal aspects that play a role in deciding who to target. The advocacy part is just as important. So yeah, to conclude, it's both for us. It's the state, it's companies, both have a responsibility. Thank you.
Thanks a lot, Maarten. It's very nice to hear something about, yeah, this lawsuit, but also the other lawsuits. Cool. I think it would be good now to hear some reflections on this topic from our legal experts, Monica Hinterlegger and Veerle Heijvaart. Now I heard that Monica has her reflections even organized in a presentation. So I suggest that Monica takes the floor now, and then we can have a discussion afterwards, which will be moderated by Chantal Mack.
Thank you very much. Welcome to everybody. Let me give some reflections on the democratic legitimacy of climate change litigation against companies. If I read the program, I come to the conclusion that actually the program addresses two questions. The first, next slide, please. Can you see the slides? Okay. Next slide, please. Two questions. Yes. The first question is it legitimate to sue companies? But the second question is it effective to do so? So I come to the first question, which is the question according to legitimacy. Next slide, please. No. Legitimacy. The third slide, please. Yes. What would be the answer? The first answer is, for me, it cannot be illegitimate for claimants to make use of a democratically generated right. The second answer is, lawsuits against individuals democratize the individual responsibility of each economic actor for climate change damage and its prevention. The third answer is, the question of legitimacy must therefore be directed to the courts, not to the individuals. How far can they go in the development of the existing rules? And to answer this, one must say there are limits also for the courts, but as Laura yesterday pointed out in her PhD defense, courts must interpret the law, and it's also the task of the courts to develop the law further. This is done in the common law, quite apparently so, but also in the civil law jurisdictions, where courts have lots of discretion with respect to the interpretation of the laws, which very often are very old. For instance, the Austrian Civil Code is from the 19th century, from 1811. But courts are no islands. This was also pointed out by Laura yesterday. They must react to societal needs, and they must pay attention to the developments in international law and constitutional law. So I come to the next point, which is effectiveness. Next slide, please. With respect to effectiveness, one can say that civil law claims already play an important role in climate change litigation. For instance, warranty rules in act emission or energy consumption standards towards certain persons, service providers, builders, architects, or towards sellers. For instance, sellers of vehicles, as we've seen in all the cases concerning emission standards of cars during the last years. Then there are the claims of investors and shareholders against their companies, directors, or senior officers for failing to disclose or adequately consider climate change risks in their business practices. And third, there is public authority liability for failures to prevent citizens from harm caused by natural events, for instance, caused by floodings or storms. Interesting in this regard are, of course, the actions in tort law. How can tort law contribute to, next slide, please, actions in tort law. Here I have 3 theses. The first thesis is, next slide, please. Tort law is not the most effective way to approach climate change damage, but tort law has some merits. What are the merits? Tort law instruments are available, already available. They need not to be created in a tiresome political process, as must be done with public laws, new public laws. And the second thing is tort law instruments are very flexible. Tort law also provides compensation for victims. This is the compensatory function of tort law, and induces emitters to lower their emissions of greenhouse gases, the preventive function of tort law. Tort law is enforced by private parties and not by public authorities. And also very important, tort law can cover cross-border damage. The second thesis is, next slide, please. With respect to tort law, climate change liability must be addressed to entrepreneurs and operators of industrial installations. Why so? There are several arguments for this. The first argument is the factual argument. They are the main emitters of CO2. The next argument is the justice argument. They profit from their activities. The third argument is then the efficiency argument. Entrepreneurs and the operators of industrial installations are, according to the economic theory of law, the cheapest cost avoiders. They have the best information, or should have the best information on the risks, and they are in the best position to control the risk. They can spread the loss by insurance and their prices, and addressing liability to operators of industrial installations makes use of the market mechanism in order to reduce CO2 emissions. And another effect is that by addressing liability to the operators, consumers are made to bear their share by the market mechanism. The third thesis in this regard is a not so optimistic thesis, because the third thesis, next slide please, shows that tort law encounters fundamental problems when it comes to climate change damage. The primary cause of action that is available now is fraud liability. And there we've got the problem of unlawfulness, because the unlawfulness must address activities that were made in the past. The next problem is the concept of causation. The traditional concept of causation in tort law must be adapted to cover also minimal causation and proportional liability. And then we have the problem of legal standing. And my thesis is that mass damage needs effective instruments of collective redress. So the consequence will be that tort law also must change, must adapt in order to address climate change damage in a proper way. Thank you for your attention.
Thanks a lot, Monica, for these very thorough reflections. I think we can now turn to Professor Veerle Heijvaart for her reflections.
Yes, hello everyone. Thank you for having me. Dr. Burgers, I presume. It's a real pleasure to be here and to continue this celebration of Laura's excellent PhD. Right, I have some additional reflections on this subject, and I've thinking about, well, is there a difference in terms of the legitimacy of judicial activity either targeted towards public authorities or targeted towards private parties? And they complement Professor Hinteregger's comments really nicely, I think, but they sort of they suggest a slightly alternative additional framing or a way of thinking through things. And to answer the question, I'm actually going to answer it twice. I'm going to answer it first in a more kind of legal conventional way, and then I'm going to answer it in a slightly more, pluralist way. So first of all, think about the conventional answer to are there fundamental differences in the legitimacy of litigating public authorities or private parties, the businesses. I think the conventional answer would probably be yes. Yes, there are fundamental differences there. And there are a number of reasons why we should look at this kind of litigation through different glasses. And one of them has to do with the fact that, well, when you are challenging public authority, and basically you have a dispute between, from a legal perspective, unequal parties. You are challenging parties, you're challenging institutions that have a number of legal competencies that you do not have. If you're challenging a private entity, then from a legal perspective, again, in terms of legal competencies, it's a fight between equals. And that kind of, arguably, you could say, well, that means that we need to be more open, more towards allowing legal challenges against public authorities, because there is this threshold that private parties face. They are basically kind of like, they're trying to speak truth to power. They're dealing with sort of higher power, and you have to kind of accommodate that in terms of allowing standing more easily, in terms of giving them a higher level of admissibility. So you can look at it from that perspective, that it's a different kind of relationship, and that affects arguably the legitimacy of one versus the other. Then there's, of course, another, very frequently mentioned point that's made in the kind of conventional framing of legitimacy and litigation, which is that, well, the state is supposed to serve the public interest. Businesses, on the other hand, are supposed to serve the shareholder interest. And that sort of, that prima facie, that would lead you to a conclusion that, well, if the state is supposed to serve the public interest, then arguably challenges that are made in the public interest, that are proclaimed to be in the public interest, are more appropriately levied against the state. And you could say, well, that's not the case for private parties. As long as they are not acting in breach of the law. If they're not acting in breach of the law, then we should have no expectation that these parties are going to pursue the public interest, just as much that as we shouldn't have any kind of expectations beyond obeying with the law that you and I are going to act in the public interest. Okay. So that again sort of would skew it towards basically validating litigation against the state or litigation against public authorities more than litigation against private parties. However, remember, we're still in our very conventional way of thinking here. And then we do also have to acknowledge that actually, formally speaking, this litigation against companies typically does not present itself as litigation in the public interest. Officially, it's litigation in the private interest. Most of it is, as Monica pointed out before, is, you know, tort-based litigation. And of course, the most famous example here, the Liuya versus RWE case, that's, you know, that is a private individual making a claim against a private company in order to deal with the financial harm that they are very likely to suffer as a consequence of the actions of that private company. That is bog standard, classical, private Aquilian responsibility. And that kind of private, and also what's being claimed here, I mean, I think the sum is in euros, is it what, 19,000 euros? That is, you know, that's also kind of like sends a strong message that, well, this is basically a private claim that's happening here. And if it's a private claim, if we are operating in the sphere of Aquilian responsibility, then, you know, basically, you don't need to have a breach of the law. That's not traditionally part of Aquilian responsibility. That's not part of, for example, UK law on nuisance or Article 1382 of the Belgian Civil Code. That's not required. I mean, like, it's not as if it's, you know, if there is no specific law that people should, you know, handle, you know, keep their tigers safe, that doesn't mean that you wouldn't be responsible if you had a tiger and the tiger attacked your neighbor. That's kind of, you do not need this kind of legal breach for Aquilian responsibility. There's quite an interesting and really quite extensive case of the UK Court of Appeal, Barr versus Biffa, on whether or not a waste treatment company was responsible for basically the stench that it produced and the nuisance that caused for the people living in the neighborhood of the waste treatment company. And it was argued, and the conclusion of the Court of Appeal was that, well, the fact that there was not a clear sort of breach of its regulatory responsibilities, that apparently this waste treatment company was operating within the boundaries of its permit, didn't mean that it wouldn't have a responsibility in nuisance. The two are separate. So if you look at it from a kind of very conventional perspective, yes, there is definitely a different basis to the legitimacy of either suing the state or suing private parties. But that doesn't mean that only one is legitimate. There's just the basis is different. That's, of course, that's, you know, when we think very sort of, this is classic legal thinking. There's nothing very kind of, you know, extraordinary going on here. But then, of course, like, I mean, we can pierce that veil of formality a little bit, right? Like, okay, if we look again at a Liuya case, yes, you can say, well, you know, this is an individual suing for damage that he's very likely to incur. But we also know that that the real goal here is a different goal and is a much more indeed sort of public interest type of goal. And that basically perhaps what that arguably what Liuya and also German Watch is trying to achieve isn't so much that this 19,000 euro gets paid, but it is that a kind of precedent is set that affirms that these large emitters, these carbon majors, have an important responsibility here. And that kind of that pulls us, that basically what that does is it invites us a little bit to rethink, to look at these boundaries between public and private law. And here we should you know, be open to the argument that are those boundaries really as kind of formal and as fixed as the conventional account of law would suggest. And so then we're kind of in the less traditional answer, the second answer, the last one. And that one basically would there you would be aware of the fact that arguably the distinction between states and businesses when it comes also to matters such as climate change in a number of aspects can be overstated. For example, differences in legal competencies, can be overridden by realpolitik. So, businesses can dominate the public agenda. So even if it's officially the state that is acting, it might well be Exxon that is really acting. Amazon is more powerful than a number of countries located in the Amazon region. So there are a number of kind of factors that might make you think that, well, basically there's legal strength, but then there's also sort of real power, and that real power can affect legal strength quite seriously. So maybe we have to kind of like not take that legal distinction that seriously. And then, the distinguishing legitimacy between public and private fades a little bit. And in that context, it's maybe also useful to remember that, we do have, quite a few functional equivalents for kind of in between public and private law, maybe more than we are readily aware of. For example, and this is something that Laura will be very familiar with, there is also non-contractual liability for public bodies. It's not just something that exists for private bodies. And so, for example, the Carvalho case is based on non-contractual liability claims. And then on the other side of the equation, you have, for example, you also have legal instruments that already respond to this, this disequilibrium in power between, for example, like people like Saul Liuya and entities like RWE in terms of, like, for example, consumer protection provisions, etc. So we already have quite a few of these legal provisions that indicate that there can be quite some similarity between state and business, basically. And we definitely discern these tendencies nowadays that seem to illustrate the kind of dissolving of this clear, stark, formal distinction between state and business. In the whole kind of, transnationalization of law debate, there's a strong interest in kind of like exploring the continued usefulness of having such a stark distinction. There's a kind of rise of private governance, which sees private parties overtly and explicitly behaving and pursuing what they think, whatever their version of the public interest is. There's a thriving literature and a thriving discussion when it comes to the application of human rights to business, human rights for business. So we see from a range of different vantage points these these boundaries between the public and the private sphere being questioned, being placed under under investigation. And now, on the one hand, when it comes to climate change litigation, I think, well, on the one hand, that opens up a number of really positive avenues, because, for example, it would allow, or it would accommodate, to a degree at least, the introduction of public interest reasoning also in litigation vis-a-vis private bodies. It would allow the introduction of human rights argumentation in private law settings. And also that might mean that, for example, that it might become possible also for, say, civil society organizations to act and to sue at a time earlier than when there's an actual real risk of harm or actual harm that can be demonstrated. So there would be definitely some advantages to that kind of reconceptualization under a more kind of pluralist understanding, and that doesn't draw such tight boundaries between public and private. But we also, I think, need to be aware of the flip side, that it's not all wine and roses. There are also a number of challenges that relate with this as well, that correlate with this as well. And particularly, we need to be aware of the fact that then, basically, we are engaging with the notion that we see private actors, large businesses, carbon majors, as having certain public interest responsibilities. And but with great, we know that with great power comes great responsibility. But the flip side is also true. So it also kind of empowers private actors to be bestowing those responsibilities on them. And that's especially the fact when we recall, and that was beautifully illustrated in Laura's defense yesterday, that the public interest is a very difficult and slippery and fragmented notion. The public interest is something very different when you look at it from the perspective of the boomers versus from the perspective of future generations, for example. And so by bestowing these kind of responsibilities, it also means that then you are effectively recognizing at least a degree of authority for the private sector to play a part in defining what the public interest is. And also in kind of, for example, in exercising judgment and in exercising discretion, because this is inevitably part and parcel of decision-making in the public interest, that we traditionally recognize that the bodies that do that have responsibilities for that, can operate with a degree of discretion, that they can exercise judgment. We see that, for example, in human rights litigation under Article 8 of the European Convention. So it comes with those kind of connotations as well. So it's at the same time, the bottom line is, there is a way of looking at this debate that kind of blurs the boundaries between the public and the private. And there are intriguing, opportunities to be explored along that pathway. But any act of responsibilization, I think, is also an act of empowerment. And that is something that we do need to be conscious of. That's all.
Eva, is this the point where I take over? Yes, thank you so much. Thank you for the wonderful presentations and reflections by Laura, Maarten, Monica, and Vera. And now we go to the discussion where also the many people attending this wonderful webinar get the chance to say something. So I see that some people are already typing questions in the question and answer. Please keep doing so. In the meantime, I'm going to read the first two questions which were already posed during the presentations. So to Maarten, I have a question on the role of the Paris Agreement. So the question is, what is the role of the Paris Agreement in the case with regard to government funding to KLM? Would you like to answer that, Maarten?
So of course, thanks for the question. Yeah, we use the Paris Agreement in our argument, and what we're saying is that the Dutch government is currently not doing enough to meet the international conventions, and that's the Paris Agreement, but also, for instance, the Oslo Principle, and also other commitments to stop with fossil fuel subsidies. So we use the Paris Agreement.
Thanks so much for this, Maarten. Then I'm going to read the second question, and this is to the entire panel. So this will also give you a chance to react to each other's presentation. So I will read the question and then give the floor to the speakers in the order in which you gave your reflections. So the question is, if a government has liability for climate change, would it be an appropriate remedy to require the government to levy a carbon tax on polluters in view of regulation to prohibit carbon emissions? Wouldn't this be a better way to offset the externality of private actors who have hitherto been allowed to pollute the air without offsetting costs, and at the same time deter such emissions through economic means? So the question is about the possibility to levy a carbon tax on polluters rather than regulating to prohibit carbon emissions. Dr. Burgers, would you like to be the first one to say something about this?
Yes, thank you very much. And if you allow me, I will also use this occasion to compliment the other speakers with their super interesting reflections. I really have greatly enjoyed all that has been said so far. So if I understood this question well, the question is, can we ask a judge to order a government to impose a carbon tax? And I am not sure whether that would be possible, at least in the reasoning of the courts in the Urgenda case, important was that they only ordered a certain goal of emission reduction, but they left it to the states to decide how they would reach this. And that was an important argument from the courts, responding to the critique that they would have overstepped the boundaries of their role within the separation of powers. That being said, on a personal level, I would be in favor of such a carbon tax. But that is, I think, another question.
Wonderful. Thank you, Laura. Maarten, would you like to respond on this view?
Is this addressed to me? Yes.
No,
Okay.
I was first asking Maarten, and then I.
Okay. Yeah.
Yeah. Then I get.
I think Laura gave a very excellent answer, and I can maybe give some reflections on what we're saying with the KLM lawsuit, and what we're saying there as well. What's important for the climate is that carbon emissions are going down, so that's what we're demanding. And of course, we have all sorts of ideas on how you can achieve that. For instance, with a carbon tax, but what we're saying is, well, it's up to the government, it's up to KLM on this deciding how they are going to do that.
Thank you for that. Yes. And Monica, would you like
to... Yes. I agree with Laura that an order by a court to initiate a carbon tax is not possible. One cannot imagine that the court has the competence to do so. A carbon tax would be a very effective way of addressing climate change problems. And I think we all would be in favor of a carbon tax. Even the economy would be in favor of a carbon tax. They only have the problem that it need be a worldwide carbon tax, and this is when the further problems start. How can you initiate a carbon tax that is worldwide? And the third point in my answer is a carbon tax would be wonderful, but it does not mean that all the other instruments are not necessary. Actually, we need all the instruments, and I want to point out with respect to tort law and civil law that the lawsuits that we've seen so far were not successful on the one hand from a legal point, but they were very successful from a practical point of view. Because if you read the statements by all these economic actors, by all these industry actors, they all say we want to be carbon free until 2030, 2000, I don't know. It's for all of them, it's a starting point to think over their management strategies, and it's really the case with the airport in Vienna. They are claiming they will be carbon free in the near future. Even Rewe now says we will be carbon free in the near future. So one also has to see this result that comes from civil law cases.
Yes, wonderful, Monica. This also creates a nice bridge to Veerle's observations on the responsibilities that private companies want to take themselves in light of how they define the public interest. Veerle, would you like to reflect on this idea of imposing a carbon tax?
Yes, well, I mean, obviously it would be, quite controversial to kind of sue for the imposition of a particular type of regulatory strategy, given that there was already quite a lot of pearl clutching about the fact that the court went beyond just saying what the Netherlands is doing is not enough, but actually set a minimum expectation of it should do at least this in order to comply with its duty of care. So already setting just a bare minimum of positive expectation for action was seen as quite intrusive in the policy and regulatory process. So a court basically validating a demand for achieving this goal via a particular type of strategy would be, I think, quite, would go quite far. Legally speaking, the only sort of scope that I would see in trying to kind of mount an argument for, defending in that sphere would probably link to the proportionality principle, in that, in accordance with the principle of proportionality, regulatory interventions need to be proportionate to the goal that they need to achieve. Now, typically that kind of principle is used in order to scrutinize the the intensity, the strictness of regulatory principles. But if they have to be commensurate to the goal, maybe there is scope there to also, for example, say, well, this particular regulatory strategy is not proportionate because it has no way of achieving the set goal. So there might be some, it would be a kind of novel line of argumentation, but given that, suitability of the measure and effectiveness of the measure are two kind of ingredients in order to gauge the proportionality of a regulatory intervention vis-a-vis the public interest goal, there might be a bit of mileage in trying to explore whether it can be given a kind of, like a positive, more activist interpretation, rather than only a kind of, how would you call it, gatekeeper interpretation, because typically we give it a gatekeeper interpretation. That is, if you're going to try to mount a legal argument to kind of put forward that a particular type of regulatory strategy should be used, I think that's where my explorations would start. But that's just a kind of, off the cuff first response.
Thanks so much for this. In the meantime, the Q&A box is also being filled with wonderful questions. So I'm just going to collect some that I think have slightly connected themes. So one question is about the comparison of UK law with international instruments. And then the question is, if, for example, the UK Climate Change Act of 2008 was effective, there would be little need to resort to civil law. Would the panel agree with this? Maybe Phil has some ideas on this, but I will also read another question that gives a somewhat broader scope. So the second question for all panelists is, regardless of whether a claim is brought against a state or a company, do you think environmental law and litigation can be truly effective and sustainable in societies and a world that is built around economic growth as the main priority? What are your thoughts on the role of law in a transition towards a post-growth society? So let me start with
Laura, I'm sorry, Chantal, would you mind, because I was taking notes on the first, would you just mind quickly repeating question number 2?
Yes, of course. So question number 2 is how you think about the effectiveness of environmental law and litigation in a society that is built around economic growth as the main priority. So what are your thoughts on the role of law in a transition towards a post-growth society? And then, Veerle, would you maybe like to be the first to answer? Because I think you could say something about the UK.
Okay, yes, all right. Well, it's kind of, it's in a way, it's really nice to be able to talk a little bit about UK climate change law and policy, because at the moment, given the peculiar state that the country is in on different, on different levels, there is still kind of like with regard to climate change, the UK has for a while been kind of like one of the better performers. And for example, it was one of the first countries to adopt a clear climate change act with clear sort of rather long-term targets in it. Now, I think initially the targets were for the UK to achieve net zero by to achieve an 80% reduction by 2050. But last year, that target was ratcheted up to net zero by 2050. And I think that's kind of in line with what the general kind of the more ambitious countries are informally saying as well. But so in the UK, it is actually part of law. And that's, of course, that's a very positive thing. Also, particularly, for example, in the context of Brexit, it was clearly no accident that just, you know, in that same period, it was the UK that was going to host the now postponed COP26. So they're clearly sending a number of signals that, you know, UK, either as part of the EU or not, they intend to stay engaged, they intend to stay committed, and they intend to stay a kind of like leader in the climate change debate. And it's kind of nice to still have these positive messages emanating. So that's all good, but does that mean that we won't have to resort to civil law? Well, I'm not sure, because first of all, the problem with these kind of long-term targets is that, you know, you have to kind of like put your faith in the willingness and in the effectiveness, the ability of consecutive governments to actually achieve that target. And you have to do that for a really long time. And, you know, you could be at, and in fact, this is, I think, an argument that the Dutch government also tried to make in the context of agenda. We could be in, say, 2047, and there could be still like a massive leap to actually achieve net zero. But the UK government could still say, well, it is still theoretically feasible, and therefore we are not acting unlawfully. And given the kind of the traditional kind of high deference to public authority in judicial review, it's questionable whether such I think it's very likely that that would be successful, that argument. So the kind of the long-term nature of these targets does mean that it takes a very long time before you can effectively hold the government to account. And finally, I just want to flag up here also I think Maarten will probably be familiar with the Heathrow case, which was won by the claimants on appeal last, when was it, May 2019, I think. Or no, it was later, but anyway, the Heathrow case won on appeal. Now, in first instance, this case was lost notwithstanding the Climate Change Act. The Climate Change Act didn't manage to kind of put a halt to a development that would clearly have very negative consequences in terms of making the goals in that act achievable. And so it was stopped for other reasons. Basically, on the basis of planning law, UK government is required to take into account all aspects of climate change policy. And climate change policy was seen to also include its commitments under Paris. It hadn't reflected on those commitments. That was the reason why the claimants were successful on appeal. But the Climate Change Act hadn't helped them in being successful. So that kind of already illustrates that we can't take for granted, just because there is a piece of legislation with laudable long-term targets in it, that therefore we won't need to rely on alternative mechanisms to stave off catastrophic climate change. Sorry for talking so long.
This was wonderful, Birte. Thanks so much for your reflections. And I think it's also nice that we have such an international panel, so we can ask some questions on the comparison between countries. So I would like to ask to add one other question to Monica before we continue, because the question now is, would it be possible to start a case that is similar to the KLM lawsuit in other countries? For example, could there be a lawsuit against the Austrian state relating to state aid for Lufthansa to save Austrian airlines? So Monica, I would like to add that question to the more general question on how effective environmental law and tort law can be to establish a post-growth society.
Okay, thank you. A very difficult question, I must say. To the first question, just a short addition to what was already said. We have in general in environmental law the problem of the enactment deficit of public law. And this is also the case in climate change law and in the climate change area. And so again, actually we need all the instruments that are available. It is a very clear sign that even the European Union resorts to the private enactment of public law principles and public law rules. So sort of private enactment can be complementary to the enactment of public law by public law measures. The second question is a very difficult question, and actually I cannot answer it on the merits because it would need a lot of research to do so under Austrian law. Actually, I cannot see much light in this, I must say, but this answer is an answer that is not based on thorough research of this question. It's a very difficult undertaking, I would say.
Thank you so much for your considerations, Monica. It's really wonderful to have you here again for a second day, and I'm so happy that we get to have this conversation. So then we're going to Maarten, and to Maarten I'm also going to add another question that was posted in the Q&A box. So the question to you, Maarten, is I wonder to what extent the obligations of conduct under the Paris Agreement, like the NDCs under Article 4, Section 2 of the Paris Agreement, actually can be invoked in the Greenpeace versus the Netherlands case. In my view, these obligations operate as reciprocal obligations under traditional international law, meaning they operate on an interstate level. How could these obligations then be invoked in a dispute between a private party, Greenpeace, on the one hand, and the state of the Netherlands on the other hand? In that case, shouldn't these obligations have a special character, like positive obligations under international human rights law? Maarten.
Yes, thank you. Very good question. And I think I might not have been very clear enough on my last answer. But as I said in my introduction, is that our argument is based on the European Convention on Human Rights. So indeed, you're right. It's based on the positive obligation of the state to protect its citizens. Yeah.
Mm-hmm. And would you like to add something on the more general question of how effective these kind of cases can be?
Yeah, indeed. And I think, as I already said in my talk, that it's also another aspect is also the advocacy part, and I think that is, well, if you're talking about degrowth, also something to consider. And I think yeah, a lawsuit like this can also play a role in making a problem better understood, create more support for solution. It's even yeah, beyond the courtroom. So in that perspective, I think it's definitely also an interesting approach.
Mm-hmm. Yes, so it makes more visible the problem in society. I see Veerle wants to react to this, please.
Yes, in terms of also like using international law in these kind of in this type of litigation against the state, I think the kind of, well, if you're trying to use it as a direct legal basis, typically, I think in most jurisdictions you won't get very far, because you will get the standard reply that, you know, this international legal obligations bind states vis-a-vis each other, but there is no kind of direct effect, that direct protection that individuals or private parties can derive from them to use in a court of law. But what we've also seen, and in your agenda that was very prominent, is a willingness on the part of the courts to use these legal obligations as interpretive tools to kind of like give direction to give meaning to the legal bases that are actually formal official legal bases. This is sort of kind of, I think in Urgenda they called it like the reflexive quality of these of this kind of more informal law. And I'm assuming, Maarten, that this is also how you are using the Oslo principles, for example, as a kind of way of steering, like how should these human rights be interpreted in this particular context of climate change. So, and I think that's a kind of like very plausible development. I do have a little bit also of misgivings about referring, for example, to Oslo principles, etc., as legal principles, not because I have anything against the Oslo principles, and they've been drawn up by, you know, an eminent group of people who have, you know, the good of the planet at heart and stuff like that, just like, you know, the climate principles for enterprises. But if they can do it, other groups can do it too. And they are doing it. And then you get stuff like the innovation principle and what have you. So this kind of, if this pathway is open for one kind of private group, it's open for all of them. And that does kind of, you know, we need to kind of, if you open the door, you do need to think about who is likely to come through.
Thanks so much. That's an excellent observation. Very true, of course. Then we go to Laura. Dr. Burgers, I also have an additional question for you. Namely, do you think that climate lawsuits, both against states and companies, can have a democratizing power or effect? Do you think that they can boost social awareness on the need for climate action? Or, to put it in other words, to make what is now perceived as an intergenerational issue an important concern for the majority of citizens? And then, as an additional question, did you consider empirical research on the possible connection between litigation as a cause and democratization as an effect? A lot of questions, Laura. What would be your considerations?
Well, thanks. I did not fully catch, I think, the last part of the last question.
Would you like me to repeat it?
Yes, please.
Yes, but the final part of the question is, so to what extent can climate cases make what is now perceived as an intergenerational issue an important concern for the majority of citizens? And did you do any, or did you consider doing any empirical research on the possible connection between litigation and democratization, with litigation being a cause for further democratization?
I think that is a very nice question. And I had to reflect a bit because I was wondering how the person who asked this question meant democratization, but I understand it to be that I think it's Carlotta who asked this question, want to know whether indeed these climate cases have the effect that the climate as such is put as a problem more vividly on the agenda, indeed raising awareness and making this problem that seems to concern future generations into a problem of us all. And my answer actually would be yes. I think that the climate cases can do that and are doing that to varying degrees, of course, depending on the circumstances. But for example, what I find very interesting when we look, okay, I will come back again to the Urgenda case if you allow me, is that the Court of First Instance allowed standing for future generations in that case. And then, because actually at first instance, the state did not even object to this. And then on appeal, the state did object to the standing of future generations. And the court did not truly consider that objection, saying that Urgenda already had standing because the interests of people who are currently alive already suffice for this claim. So that indeed suggests that over the few years, because the Urgenda case was launched in 2013, and then the Court of First Instance rendered its decision in 2015, but then we're already 3 years further when the Court of Appeal rules on this case. So there, the Court of Appeal said the interests of people now suffice, which indeed very much suggests that the problem is no longer seen as something for the future. It's our problem now, and I think, well, that's a suspicion I have, because that decision was rendered just after a very hot summer with a lot of heat waves, also in the Netherlands. And I just always have the feeling that this must have played a role there somehow, perhaps. Was there another question, Chantal?
We have many more questions, Laura. So
yeah, we have a lot of wonderful questions, I think.
Yes, I still have 5 questions on my list, and we have 14 minutes left for the webinar. So my suggestion is that I read out all the questions, and then we make one more round to the panel, and you can reflect, you can give your final reflections on the topics. So 5 questions. The first one is, if private actors would be liable for damages under tort law for greenhouse gas emissions, wouldn't that mean that every individual could be held liable for climate change? For example, for driving a car, eating meat, etc. So that's the first question. Second question is about greenwashing. Do you believe that a claim against greenwashing advertisements could be successful and efficient regarding climate change litigation? And so if companies pretend to produce in a green manner, but then later on you find out it's less beneficial than they claim, could this be the topic of a claim? Then I have a third question from a slightly different angle, namely a researcher who is working on ecocide as the concept of criminalization of large-scale destruction regarding the climate. And her question is what your thoughts are on the use of private law versus criminal law in creating a responsibility and deterrence for companies to avoid environmental harm. So from the perspective of ecocide, how do you see the relation between private law and criminal law? Would you say that one is more suited than the other? The fourth question is then about the aspect of time. So if you consider that even the Paris Agreement's commitments are, I'm not sure whether it's meant ambitious or unambitious, but the question is we have 10 years to act, and some cases like the Luya case take a lot of time, 5 years in this case, and there's no final judgment. So how do you look at climate change litigation with an eye on the time that we need to prevent further climate change? And then the last question, and Laura might guess from who this is a question about the new election program of a Dutch party, the VVD, which launches a frontal attack on courts with agenda as an example to fight alongside the European Convention on Human Rights, collective actions and civil society driven lawsuits. So in this new election program, the party is arguing that there should be less of these kinds of lawsuits and less influence of the convention. Similar attacks were waged earlier in the UK as well as in other countries that are generally considered to be governed by all kinds of populists. What is your stance on the risks posed by populist backlash against courts in relation to climate litigation? And this question now is, of course, from your second PhD supervisor. So these are the 5 questions we have for our final round. And I'm going to give the panelists the turn to speak, but please keep it brief because we have only 10 minutes. And I'm sure that Laura and Eva would like to speak some concluding words. So Laura, you were the first one on the panel. What would be, or on which question would you like to comment, Laura?
Well, thank you very much for all these wonderful questions. And I think we do not have the time to indeed address them all, and definitely every one of us. So to be very short, yes, I agree. Climate change litigation is too slow a mechanism. We need much more than climate litigation. It can be one of the things that help us to indeed become more aware that action is needed. I do think that greenwashing could be an interesting basis for a claim that we could base in European Union law, namely the Unfair Commercial Practices Directive. So I would like to do more research on that, perhaps. And then I will say something very short on ecocide. So I'm very much interested in this whole area of law that is driven by a non-anthropocentric approach. And I think this includes ecocide. As far as I understood, ecocide endeavors really focus at international criminal law. And as far as I know, international criminal law is not known for its effectiveness. So there I'm a bit hesitant, but I do think that that should not discourage people who are advocating for a thing like that, because I think the symbolic value of ecocide is very big, and it could also have wider effects than only implementation in the Rome Statute, for example. So I will keep it at this. Thanks.
Thanks so much, Laura. Yes, and I think that indeed relates to the question not only of awareness of what is happening, but also of the symbolic value of laws and lawsuits. Maarten, what would be your final reflections?
Yeah, just two short reflections on two questions. I think the long time that climate litigation takes is a valid point, of course, and Laura's response that it's just one of the important tools that we have is very important. And I would just wanted to add that for the KLM lawsuit, we opted for summary proceedings. So that means that this year we already have a ruling, which is, of course, this bailout is happening now. So we cannot wait 10 years. Then about the greenwashing, I think what's interesting in the Netherlands that this is already happening, maybe not so formal, but you have the Reclamecodecommissie, which is like a code of conduct committee for advertisement, and for numerous fossil fuel companies, they have already stated that their advertisement was greenwashing. For instance, also KLM claimed that they are flying on biokerosene, while it's just 1%, and now they cannot make that claim anymore. So that's indeed really interesting.
Thanks so much, Maarten, also for bringing us this perspective from the NGOs that are actually doing the work on the ground. And I think you also emphasize very clearly the relation between substantive and procedural law. So summary proceedings indeed give some speed to this agenda. Thank you so much. Then Monica, what would be your final reflections?
I want to comment on 3 points. The first is the point on ecocide. I think criminal law is important, but criminal law is always a matter of last resort. And we should not say let's do it by criminal law. We need all the instruments, the civil law instruments, much better fine-tuned than criminal law. And like this, I think we come much farther with civil law than with criminal law. Then the question with respect to greenwashing, as was already pointed out before, this is already a matter of case law with respect to competition law. And in Austria, we have a very general paragraph 1 of the competition law statute, and this would be a matter that would be decided under this paragraph 1. So this is, I think, a question that can actually be answered by the law right now. And then the most important question for me is the question with respect to the consumer liability of the individual. And I want to answer
Afraid the connection is blocked for a moment.
Yeah, and it's not coming back.
Liable in the first place.
Yeah.
Monica?
Monica, sorry, Oh, Monica, the connection fell away for a moment. So could you please repeat the last part of what you said?
Okay. Okay. Can you hear me now? I was
Yes.
my internet connection was off. So only the last word to the consumer. I don't know if you heard what I said. I would say the consumer always pays the price. In the end, it's always the consumer who pays, and it's not a wise decision to make the consumer liable in the first place, because this consumer is not the cheapest cost avoider. The consumer has not the information, and the consumer has not the possibility to control the risk. Thank you.
Thank you, very clear, and thank you for your wonderful reflections on all these points, especially so much from the legal basis in which we can ground the claims. Then, Veerle, what would be your final reflections?
All right, well, I think that most of the points have been covered by now. Because I was also going to make the point about the consumer when it comes to ecocide. Yes, there is an important role to play, I think, for criminal law. I think from a symbolic perspective, it is really important. And it's particularly important because one of the big challenges that we faced with regard to kind of the effectiveness of environmental protection in the UK, for example, has been what some people in the past have called a ritual trivialization of environmental claims as they were made before the courts. That basically judges would really kind of give minimal penalties, issue minimal penalties for serious environmental infractions. I think having that kind of like this language of criminalization of responsibility is an important an important ingredient to the overall picture and debate. I want to end by saying something about the populist backlash, which I think is the one point that hasn't been fully addressed yet. And I mean, it's a little bit of a shame to end on a sort of a slightly dark note, but yes, I'm very concerned about that. Like the only country at the moment where we're not seeing, country in that sort of, that seems to be finding itself in this particular headspace, where we're not really seeing such a backlash against the judges is the US, and that's just because the Trump administration has packed all the courts. And it really kind of does show that pivotal strategic importance of having courts and, also of having independent courts. There are conversations ongoing in the UK, for example, at the moment to really also claw back more, discretionary space for the executive, really kind of limiting scope for judicial review. These are concerning developments. These are deeply concerning developments. And that is definitely something that I think as environmental lawyers, we cannot take the luxury of ignoring these general developments in administrative law, because they may have a huge impact on the extent to which environmental claims will be able to be pursued in the future. So yes, we should be on alert about that.
Thanks so much, everyone, for your final reflections. And with this, I hand back to Eva and Laura for the conclusion of the webinar.
Yes, thanks so much, Chantal. We are indeed moving towards the end, and time flew by, in my opinion. I really want to thank all the panelists and speakers for their wonderful and enlightening reflections. I am not a climate change expert myself, and I really learned a lot today. So thanks for that, but also thanks to the audience, because I think you asked very well-informed and interesting questions. So that was very nice of you. And also, thanks to Lisa and Gijs making it all possible, because this new format was really, we couldn't do it without you. Then I want to conclude with wishing Maarten and his colleagues good luck next week. I really hope you do win the case, of course, and I wish the rest of all a very good afternoon.
Thank you very much.